All right, welcome everyone. Thanks for tuning in to this episode of the Hawaii Retirement Show. Today we're joined back with Stacy Takekawa, her second time on the show. If you haven't listened to the first time she was on, we did a great kind of high level discussion about all the different documents in estate planning and the different roles, and a good listen to give you a good overview of what kind of estate planning is all about. But today we're happy to have her back on. Appreciate you taking the time. We're going to talk probate today, all things probate. Um, Hopefully we didn't lose listeners right there. Hopefully people are still on, excited to learn a little bit about probate. But yeah, Stace, thanks for coming on. Anything you'd like to share? Anything new since last time we talked? Anything exciting in the estate planning world, or professionally or personally?
Nothing new to share that I can think of off the top of my head. I don't remember if I mentioned it last time to give myself a little bit of a background for probate. I did clerk for the probate judge right out of law school. So that's where I started my legal career. So yeah, there's stories and experiences there that really shaped how I practice in my planning. But I am glad to be here today. Thank you for having me back to talk about probate because it really is something that is, I think you said a little bit earlier before we started, it's a black hole, for
Mhm.
people. And so let's shed some light,
Yeah,
hopefully.
let's do it. And then I'm sure we'll talk about kind of probate universally, and what I mean by that is maybe nationwide, and then maybe we'll talk about some things that are unique to Hawaii here. Um, but yeah, I don't know how to even kick this off other than should we try to define like what probate is? Is that a good place to start?
Yeah, because I do have clients who come in and I say something about probate, and I've learned over the years you can't just say it because maybe they've heard the term, but they're like, what is that? Is that a
Right.
place? Is it a what?
Right.
So, yeah, so probate is when we say probate, you end up in probate, you're going to probate, you have to do probate. What that is a court proceeding. And even that, I think, I'm not sure if people are aware. I learn new things about the different kinds of courts and proceedings we have, even as a lawyer. So there's different courts. There's a court you'll go to for a traffic ticket, right? That's different from the court that you go to for a probate proceeding. So it's a circuit court proceeding, and it depends. There's different which island you're on.
Mhm.
Each the neighbor islands are their own circuits. Honolulu, Oahu is a circuit. So it's a circuit court proceeding that deals with wills, people without wills. When a person has passed away, if there's something that needs attention that hasn't been able to be fixed outside of the court, you end up in court, and that is the probate proceeding.
Now, you don't necessarily have to go to court, right?
Right, right. Yeah,
Because I
yeah.
think some people might think, oh, probate, I gotta go before there's these lawyers, there's a judge, there's a jury, and I want to get my property that's supposed to be passed. But you don't actually have to go. It's just a court process, right?
Right. It's a court process, and we'll go into the differences in more detail, but there's informal, there's formal.
Mm,
Informal probates do not involve even a judge.
mm,
They involve the registrar of the court. The formal court, formal probate proceedings do involve a hearing before a judge. For Hawaii, and even for First Circuit, Oahu, they're implementing a process where if all the paperwork is in and all the interested people have signed off and there's no one else has filed anything saying they plan to appear or object, and it's fairly straightforward, it's possible that the court will call the case on the day of the hearing, but nobody actually has to appear. They just are saying, okay, this case is being presented to us. Everything looks good in order. We're going to grant it and then move on. So even the lawyer isn't like on the call, on the Zoom in the courtroom that day. But even if you as the client don't typically have to show up. That's why you hire an attorney,
mm.
for, let's say it does require the judge wants to ask questions, or not all the paperwork was completed, or you couldn't get all the interested people to sign the appropriate documents. Even if there is an actual court hearing where they call it like on TV and the judge is sitting there and you have to go up, if you have an attorney, you yourself don't have to go. That's why you hire attorneys. If you're going to represent yourself, you're going to end up with a formal hearing because I've never seen someone do all the paperwork correctly in that instance. And then you do have to show up and talk to the judge and the other attorneys.
Gotcha. And I think probate has a relatively negative stigma, and I'm hoping that we can kind of put people at ease because the whole idea of probate, it has a negative connotation to it, but it's there to protect people. It's there to help. It's there to really a court process there to help people, not to make your life miserable, right?
Right.
Uh,
Yeah, and that's why with estate planning it gets tricky because I'll have people come in and if there's an instance where it's a very because a lot of people think like I don't have that much money, I don't have that much stuff, I've got one kid or I've got two kids. Like it's not good. There shouldn't be a problem. There shouldn't be a fight. This shouldn't take a
right.
long time. If so if the idea is, do I need to do the estate plan? Would probate be that bad in this case? For even those simple, straightforward, everyone's on the same page cases, I still advocate for estate planning because you eliminate the unknown variables. You've got control, you can close the universe, here's what we're doing.
Mm,
But if you didn't do planning and you find yourself needing to do a probate, it isn't going to be this process every single time that requires the court hearing that takes, thousands. People think thousands and thousands of dollars and years of their life. That's in worst case scenarios. That's what happens. So again, for like the straightforward people, it's not the end of the world. When I have someone calling freaking out that they have to do a probate and they're terribly upset and they're so nervous and they're so worried and they're starting to panic, I'm like, okay, no, it's going to be fine.
right.
If what you're telling me is true and here's the what we're dealing with, it won't be that bad. So it's not the end of the world. Should we still try to avoid it? Yes, but today's show is about what if we're in it or what is it? So
Right,
yeah,
right.
probate's not the end of the world every single time. It's rarely like that big, lengthy, thousands of dollars process.
Gotcha. Okay, so let's set the stage here with the assets that we're even referring to, right? Because
Yeah.
if you have, so what doesn't pass through probate, and correct me if I'm wrong here, but I got beneficiary designations, right? If it's on life insurance or your retirement account, that stuff won't pass. If it's, do they say it's by law when it's titled like joint tenants with right to survivorship or payable on death, or is that considered by law? But the titling, right? The titling.
Yeah. I don't know if it's by operation of law or something else, but yeah,
Okay.
if you've got the titling matters.
Okay, and then trust, if it's in a trust, it doesn't go through probate, right?
Right.
So, am I missing something? Those three areas, like those assets will avoid probate entirely. Now, what doesn't is a will. Am I correct there?
Yes, that's correct.
Okay. Okay, so then, so the assets that might go through probate, we're talking most commonly, it's like real estate, financial accounts, stuff like that, right?
Yeah, so it's Hawaii. We're talking national versus Hawaii probate. I'm really not that, going back to your intro, I'm not really that versed on how probates happen in, nationally or in other
Mhm.
states. I have had sort of experiences with people from other states. Most recently, I had someone from South Carolina, so I learned a little bit about South Carolina probates, and it's wildly different. And
Okay.
California, even I do hear a lot, learn a lot about California probate proceedings because there are a lot of folks who have connections with both Hawaii and California.
Mm.
But for Hawaii, if there is real estate owned by one individual or, only an individual name. So you could have joint tenants, you could have a husband and wife or spouses, parent and child, what have you. Joint tenants or tenants by the entirety for married folks. and the last person standing is passing away, we're going to have to do a probate. If it's just an individual who owned real estate in their own name, we're going to have to do probate. If it's tenants in common, so people don't always know whether they own property with another person as a joint tenant or as a tenant in common. If you're a tenant in common, then and let's say there's two people, 50-50 tenants in common. One of those owners passes away, you have to do a probate for their half.
Mm.
So that, or for Hawaii, if it's a Hawaii-based financial institution. So that gets tricky too when I have people with Bank of America accounts,
Mm.
Wells Fargo, Citibank, some of these high yield savings accounts with national banks or mainland financial institutions. They're not subject to the same threshold as a Hawaii financial institution. So the local credit unions, the local banks. If there's an account, if you in the aggregate, so if you add up, someone has four accounts and you add those four accounts together and they're over $100,000, then you have to do probate to get at any of those accounts. So
Mm.
if you do have Hawaii accounts, like mom or dad had 20,000 at the credit union, between savings and checking, they didn't have a beneficiary. It's they're the only ones on the account and then they pass away. Hawaii does have a process for getting that without probate,
Okay.
if that's the only asset. But so back to like the benefit, what doesn't cause probate? If it is small and if it is local, it doesn't always need a probate either. But real estate that's in someone's individual name, or if the accounts add up to over 100,000, that will cause probate. The common ones I see, even when people have really well laid out estate plans and they funded their trust with most of their accounts, is sometimes these stocks. And it might not even be that much. And it's like individually owned stocks,
Mm.
not investment accounts, but they every now and then it's Hawaiian Electric stock. I don't know why.
Right.
That maybe they inherited from the parent, the grandparent, and now they just haven't. It's maybe not even worth that much,
Mhm.
but they never got it out of their name. So it's something
Right.
that they own individually outside that will cause a probate.
Yeah, that is common. And I think it's a old school mentality, not in a bad way, but there was like when they got these shares of stock years and years ago, decades ago, and it's not a bad thing if you don't like sort of cash them out, diversify, and put them into a financial institution,
Right.
but it does cause some interesting, like you said, some interesting uh processes once it needs to pass on, right?
Yeah, because you can change the ownership of the stock to a
Mhm.
trust, or you can designate a beneficiary a lot of times. Once you're doing that, you're really sometimes changing other things about the ownership, but there are ways to deal with it during lifetime to avoid probate, but that's the one that just seems to be left out every now and then.
Gotcha. And then so you're mentioning other states there. So if I need to go through probate and 90% of my assets are in Hawaii, but I have 10% of my assets in California or Washington, I'm still going through I don't need to deal with the other states' probate process, right? I'm still just focused on Hawaii.
If there's a probate required, and like let's say, so for you in your example, this person did no planning, they got 90% of everything here, but they do have some stuff in another state. You do a primary probate proceeding here in Hawaii, and
Hmm.
then you have to do, it's called an ancillary proceeding. So you do have to do sort of when I'm talking with clients, I'm like, you do a piggyback proceeding. Like it's not a full-blown probate always. Like you're not having two separate, because especially if there's a will, we'll talk
Hmm.
about will versus no will, but if there's documents, they're only going to get filed at one of the courts, and then the originals, and then the, copies will be presented elsewhere. But you can't just that's so if you have something in Washington and California, you're going to have the Hawaii probate, you're going to have a Washington piggyback proceeding, you're going to have a California
Hmm.
piggyback proceeding.
Interesting. Yeah. So I guess it can get pretty cumbersome and complicated the more, I guess, assets you have in other states.
Yeah, once people talk about that, it's like, okay, we should do some trust planning because you don't
Gotcha.
want to have to do
Right.
the waiting game there will just add time because the first state's got to get that. You can't have those all running concurrently, to get things started because the
Mm.
piggyback ones need the documents from the original proceeding. So I have I have the opposite that will come up. Someone lives on the mainland and then owns property here, and they're doing a probate in another state and they're needing to deal with the Hawaiʻi asset. So I'm tasked with doing the Hawaiʻi piggyback proceeding to California, or I have one now for Virginia, that we're working on. So it's the states will talk to each other in that way, but they do need separate proceedings.
Okay. Okay, since we're on the topic of like when probate is required versus avoidable with, the trust and the titling of documents, beneficiaries, out-of-state assets, I think we'll talk about the will, right? Because I'm sure some people might think, well, I have a will, I don't need to go through probate, right? So if you want to, I know that's probably a big conversation to have about how the will plays in the probate, but you want to give us some background on that?
Yeah, well, it's not even that big of a thing. You either have a will or you don't. And if you only have a will, it has to go through probate before it can do anything. So you have a will that says, when I pass away, I want everything to go equally to my kids, and I want my oldest child to be in charge. Great. Your oldest child cannot take your will to the bank and say,
Right.
here's mom's will, and can I have her accounts now, please? It has to go through the court has to issue a document, and it's the court document that says, so and so has been appointed as the personal representative. I'm going to throw out those terms. So
Yeah.
executor is commonly used, but Hawaii law calls it a personal representative, but same,
Mm.
as far as responsibilities and thinking of who we're talking about. So the person in charge, the personal representative, has been appointed in this state and has full powers to, deal with estate assets. So the bank wants to see that document. They don't ever want to even see the will. They don't want to see that the will says it's an equal split or who the beneficiaries are. They don't care. They
Mm.
just want to know who they're allowed to deal with and sign the paperwork to close the account, or who they, if that person tells them, make the check out to me, the bank says, okay, great. They're relying on what that person is telling them once they are court appointed. So the will, a lot of people, that's, I would say, the biggest misconception is that a will is going to do you just fine.
Mm.
Um, the will help, because you can designate, who's going to be in charge. You avoid that fight maybe with your kids if there's competing people wanting to
Mm.
serve, as the personal representative, but you don't avoid the court proceeding with a will.
Gotcha. Um, Interesting. So before we move into like the probate process and the kind of
Hmm.
the mechanics, and we'll kind of revisit informal and formal and the will and all that. I was just curious, since we're talking about assets that avoid probate or are required in probate, the transfer on death titling of a home.
Hmm.
Um, so if you could talk about that versus titling a home to a trust versus a probate and a will, because I think not too many. It's probably, I don't know. You could tell me, is the transfer on death titling probably the least common of the three, the trust or the probate?
Yeah, I would say so. I would say the transfer on death deed is not that common because it's people don't really know about it. But the way that a transfer on death deed works for real estate is similar to the way it would work for a beneficiary designation on any other kind of asset account. Um, the when there are folks who maybe don't want to spend the money, they're less expensive than a trust. So when there are folks who maybe don't want to set up a trust and they're saying, like the only thing I'm worried about is my house,
Mm.
um, we can do a transfer on death deed. The limitations of a transfer on death deed versus a trust are like your transfer on death deed can say, I'm leaving it to two people. I want like two kids.
Mm.
And you cannot say, and if, child A has passed away, I want their share to go to their kids. You can't do that sort of planning. The transfer on death deed names beneficiaries, one or more, and if any of the beneficiaries have passed away, it just goes to the others. So it's sort
Okay.
of last man standing on the beneficiary transfer on death deed. Um, And sometimes that's okay. Like I have done it for clients where, maybe there's a parent and a child, and it's like, I'm just worried about getting the property to my child. If my child doesn't survive me, and that means there's no surviving beneficiary of this deed, and it ends up in probate and our more distant relatives are going to get it, that's fine. I'm
Mhm.
not that let that be then, because
Right.
my primary goal is just taking, if my kid survives me, I want them to have it. And so, that's okay in that situation. The trust can deal with the contingencies, the what ifs. We can deal with, you've got two kids. If one passes, you want to benefit their children, your grandchildren, or you've got four kids and you only want to leave it to the three because you gave, money to your fourth child to buy a house or something. I mean, there's all of those
Sure.
different, we did this, we did that, we want to make it, as the more specific and detailed you want to get, the more strings attached you want to do, you can do that in a trust. And I think that I think I mentioned this in the last show I did with you, but I think it's a missed opportunity for Hawaii homes where you've got unique family situations. You got
Mhm.
multi-generational living, in a home, multiple generations living in a home. The older generation is the owner. If they're going to pass away, you've got the child who's been living there, taking care of the parents, helping, putting money in maybe. And then you've got the other ones who have their own properties or have moved away for whatever reason. And maybe you want to address the uniqueness of that situation in a certain way. You can, there's ways where the home itself can have rules in a trust about what are we going to do with this property after the parents are gone, or the owners are
Yeah.
gone. So the trust is way more expansive in that sense. If you don't do anything and you pass away and the property is something that needs a probate proceeding before we can change title to the new owners, that I think we're going to talk about too. The law in that case, if there's no will, if there's a will that says my house goes to XYZ, the will goes through probate, the personal representative gets appointed, they can sign a deed to XYZ, assuming there's no other issues. Um, but if you don't have anything, the law will say, okay, based on this person and who has survived this person, who are the beneficiaries? And it's not always what people think, or
Right.
sometimes crazy situations come up. Um, yeah, so that's kind of the biggest bird's eye view of the difference. And I'm probably my bias is probably coming through with I think the trust is great,
Sure.
but yeah,
I agree, and I think for those listening who might think, because I'm a big advocate of simplicity in finances,
yeah.
in investments, and simple often works. But I think it sounds like the downside to the transfer on death, one, there is simplicity, but you can't answer all those what ifs, right? And it's
Hmm.
one thing to say, well, it's just fine, it's just going to be simple. But I would say for anybody listening, maybe take that time and say, well, let me speak to somebody like you and see what kind of questions we could answer through titling it through a trust versus the transfer on death, right?
Yeah, and I did recently have a situation come up where I did a transfer on death deed with um there was a mother and son on title, and they both signed a transfer on death deed that said when they were both gone, it was going to go to the grandson. The son on title was going to go to his son. They didn't want to do a trust, it was just simpler, the father had some health issues. So it was just a matter of if something happens, we want to make sure that it gets to the grandson. Um, After the son passed away, he did end up passing from his health issues. Grandma with one of her other kids did a different transfer on death deed. And that's how transfer on death deeds work. It's you can do one, you can revoke it,
Mm.
you can just say, never mind, I changed my mind. You can do a subsequent transfer on death deed, and it's going to be the most recent one is what's going to control. So mom and son are on title. They do this transfer on death deed. Son passes away. Mom still owns the property because transfer on death deed doesn't change anything about title during the lifetime of the owners. So mom is still on title. She decides, to change her mind, or in that case, they're arguing about, capacity issues and undue influence. But regardless, we've set up, if there had been a trust and maybe someone else's trustee, you have a little bit more protection against someone changing their mind
Mm.
later, or being not changing their mind. I shouldn't say that because you can always change your mind, but being unduly influenced.
Right, right.
Just one example of
Sure.
recent memory where the transfer on death deed didn't quite work out.
Gotcha. Okay, let's switch gears to let's talk about the process, the mechanics, the nuts and bolts. So, uh, with the probate process, so I think high level we have these are the legal terms, right? Testate versus intestate, will versus
Hmm.
no will.
Yep.
Um, and I'm sure that makes a huge difference in how this whole process unfolds, right? Uh, but I guess so the core steps that I kind of came up with here that I know is so you're gonna file a petition with the court. The court appoints somebody, the personal representative. You're going to notify the heirs and beneficiaries, you inventory assets, you pay off debts and expenses, you distribute remaining assets, and you close the estate. Now, there's probably a lot we could talk about in each one of those steps,
Yeah.
but if you could just take us through your kind of high level start to finish the probate process.
Yeah, so that was a great explanation of the formal proceeding. The
Okay.
only thing I would switch is you notify the heirs and beneficiaries before anybody's appointed. Um, in the formal probate proceeding, you have to include in your petition to the court. So it's called a petition for probate of will and appointment
Mm,
of personal representative if there's a will. If there's no will, it's called a petition for adjudication of intestacy and appointment of personal representative. So you're either saying, I want the court to read the will or to look at the will that I'm presenting and say, yes, this is valid, or I want the court to say, yep, we're gonna say we're gonna rule that there was no will, and because there was no will, we're gonna say who the heirs are at that point. So it's really more beneficiaries of a will or heirs of an intestate estate.
okay.
Um, yeah. And that all has to go in the document. So you're already talking to people. People are already going to know, unless you just know everybody's address off the top of your head,
Mm,
but they will all get all the people who are identified in the document will get a copy of the document when you file it, the petition.
okay.
So when there's a will, let's say you left your assets to two of your children and you were excluding one for whatever reason,
Mm,
you still have to say, these are all of the children of the deceased person.
mm,
Two of them are beneficiaries of the will, one is not. That one is still going to be notified. So it's not
mm.
because it gives them an opportunity to say, wait a second, you know, I have
Right.
a will that says I am a beneficiary. So that's
Mm,
where I've got unknown variables and things like that. I mean, the purpose of probate, of the formal probate proceeding, because you are required to give notice to everybody, the purpose is really for the court. The court's not reading the will and saying like, well,
right.
I know Mrs. Takekawa and this is what she,
Right.
obviously it's an opportunity for all the people who are being excluded or who are being included. It's for everybody to know what's going on, what's
Mm,
what, to say this is the will from 2018, so that if one of the other kids knows, oh no, I have a will, from when COVID happened, I was with mom and we redid her will. It was 2021.
mhm.
So does it supersede the 2018? Yes, if it's a whole brand new will and it says that it revokes. It's all like, I'm
Gotcha.
trying to stay high level, but it's like
Yeah,
all of
yeah.
these things are what kind of comes into play. But that's why formal proceedings, there's notice to everyone. So it gives
Mm,
everyone an opportunity to either object or agree. The agreeing part can be helpful for making the process go faster. I mentioned earlier about whether someone has to show up at court or not. If you've got everyone's on board with what the will says, everyone's like, "Yep, that was the plan. Yep, there's nobody else. It's normal. It's the four of us kids. We're all sharing equally." If they'll all sign documents that say they're on board, then that's part of what lets the court know there's no fight here. There's no issues. We're ready to go. and the court will say, okay, everything looks above board here. We don't need to actually have everybody show up. We'll just grant this on the date of the hearing. So part of it too is because in a formal proceeding, notice, and we're talking about notice to people, you have to file notice in the newspaper to say if there's any unknown interested person. So if there's anybody who wasn't included in the petition, these are the children from other relationships or prior relationships who weren't identified, something like that. Who would come forward. It's not always that. Sometimes those notices are important when there are no children and we're dealing with,
Mhm.
we just got to find like cousins or whoever
Right,
might be
right.
related to this person because they weren't married and they didn't have kids and they died when they were 70. So we got lots of people, that we might need to
Mm.
contact. And we don't, one side of the family, you don't know the other side, the mom's, I'm dealing with the cousin on the mom's side, but we got to deal with the beneficiaries on the dad's side. So, or the heirs on the dad's side. So the notice in the newspaper becomes important to sort of find those people that you may not know of. And then also creditors, which I think we'll talk about later. But
Okay.
all of that goes into the notice part of
Right.
what you laid out earlier. The hearing happens, the hearing is usually 2 to 3 months out from when you file the document. In First Circuit, the neighbor islands are all different. All the islands are different. All the circuits are different for how long it takes before you get a hearing date. But because of those notice requirements, it's at least 30 days out. So it's usually 2 months, 3 months out. Um, and on the hearing day, if you do have to have the hearing, you go in, the attorneys go in, the judge asks for questions. Usually the judge is looking at, was everybody given notice? Because once you also have to prove that you gave notice to everyone, so you can't just say, oh yeah, I mailed this thing. And you need to have like a certified mail with a return receipt to know that the person got it.
Mm.
Because sometimes your addresses are wrong. Sometimes, people don't check certified mail. So you have to
Yeah.
like make attempts to make sure that the people are actually getting notice of what you're doing. Um, and once let's say the hearing happens, any questions or issues are sorted out. We've got the person we asked to have appointed as personal representative is appointed. Great. Yes, that opens the door to start the process. When you have a formal hearing, I just like to give people even like the timeline again. Once you have that hearing, you don't get that document that day,
Mm.
from the court. Everyone else that had a hearing that day, everyone submits their documents to the court. Speaking as a former clerk who went
Right.
through all these paperworks, you got to give them time to then receive your order that you submit that says, we're appointing Stacy as the personal representative. They have to make sure everything matches. They have to make sure if there was anything the judge asked you to do at the hearing before they would grant the petition, you have to make sure people did that. So it's a
Mhm.
process that can take another 2 to 3 weeks before you get the actual document you need to go to a bank to
Mm.
sign a deed, for property. And then, yeah, so like you said, then they have to figure out, the person represented has to figure out what are the assets we're dealing with. We know about the house. Is there anything else? Because once you are appointed as the personal representative, you're a fiduciary with there are many, many laws on the books about what you're required to do, what you're not allowed to do,
Mhm.
how you have to behave, how you have to communicate. It can be bigger than you expected because you really do. You have to make sure their taxes are filed. You have to make sure any final expenses are paid. You have to deal with debts. You have to identify debts if you can. You have to find creditors, notify creditors, et cetera, et cetera, et
Right,
cetera.
right.
So yeah, assets, debts, and then you have to tell all the people. You have to
Right.
inform all those heirs or beneficiaries. Here's where we started. Here's how much I had to pay out for the attorney. Here's how much I had to pay out for the debts. Here's how much I took as my fee, and now here's what everybody else is going to get. You can do that informally without having the court approve of what you've done. And so for family situations, again, when there's no fighting or anything, that's you can just sort of make sure everybody's okay, sign
Mm.
something that says, I'm not going to sue my brother later. I appreciate what he did and I approve of it, no questions. Then they get their check and everyone goes their way. Or the personal representative can submit their spreadsheets to the court saying, here's what I did. Can you please approve it so that I'm not going to be held liable later? And again, there's
Mm.
notice issues there. There's a certain format you have to follow for your accounting. But then you can get approval from the court and the court can discharge you and say, okay, you're done. Thank you so much. And then sometimes that will happen, and a year later, the person will say, "Oh, we got another check, or
Mm.
we got a statement or a mailing from somebody about some annuity we didn't know that the person had." If you formally close the probate, then you have to open it up again. So you have to go
Okay.
back to court and say, "Oh, there's something else we discovered." Or if it's a mainland asset, you have to either reopen the probate in Hawaii to then do the piggyback proceeding in that other state, or at that point you can just do a probate in that other state if you've already closed Hawaii. So it gets complicated the more complicated someone's assets are, but
Mhm.
that's the general start to finish in the formal. The
Okay.
informal process we've talked about is the simpler one. It's meant to be quick and simple for quick and simple estates. Um, I've had, the one I just submitted was mom and dad, daughter and husband are tenants in common on a property on Kauai. The mom passed away in 2021. They thought they were all joint tenants. And come to find out, I think they're trying to refinance or something. And oh, nope, you're all tenants in common. So we have to do probate for the mom's estate.
Mm.
Um, didn't have a will, married, two children. So there is another sibling other than the daughter who's on title. But uh, the dad, the on title, he's going to be as the surviving spouse, and the only children involved are children of their marriage. We can do an informal probate where I'm just submitting, and in that case, an informal, it's called an application for probate of will rather than a petition, or an application for appointment of personal representative without a will.
Mm.
So you don't have that adjudication word in there like you do for the petition, because adjudication implies the court and the judge were involved. So
Mhm.
informal, you submit to the court registrar. It's still a court employee, and they have experience and credentials, but they just review the paperwork you submit, and they're going off of what you're telling them. So the application has to be signed before a notary, just so that we can say that the registrar can be like, okay, well, at least I know it was Stacy Takekawa who signed this document.
Mhm.
But if I say there's only two siblings and there's a third one I'm leaving out on purpose because I'm the bad actor, the registrar is just going to say, well, I can approve what you've sent me based on what you sent me. If that other sibling comes forward later and says, wait a second, I was left out, everything I've done is not, oh, but I was court appointed, so I'm covered. No, it's you lied.
Mm.
You're not off the hook for that. It's so it doesn't work again when it's anything complicated or weird, you still have the court, or you don't have the protection of the court when you're doing it informal if you're not being truthful. But if everything's on the up and up and you're just like, yep, in my case with my family that I just had to submit for, we should have those documents back within a week of submitting to say, here's the letter, the document that is issued that says, Stacy has authority to act. So in this case, the husband's going to have, or the dad's going to have authority to act and sign the paperwork to take his wife's interests, give it over to him. And then he and his daughter and his daughter's husband can sort out the titling now and the refinancing and all of that. And all of that will have happened within, like I said, a week versus months and months and months.
Gotcha. One question that came to my mind was, let's say it's there is no will, and the court needs to appoint a personal representative. Um, do they just does one of the siblings just kind of nominate themselves, or how do they go about deciding who that person will be?
Yeah, so the law gives a list of priority who gets to go, who gets to be appointed.
Mm-hmm.
It starts and they don't differentiate between will or no will. The law says if they're, the person who's nominated in a will is first. So there's no will, then we go to, I should look at it before I lie, but it's, spouse first, and then this is like embarrassing
No,
that I
no,
don't
that's
know
okay.
it
So
off the
there is
top of
there
my
is an
head.
actual there's like a document. It's not just somebody can
It's
just come forward and say I'll do it, and then they say okay, that works. Or
Yeah, so that's usually how, if you don't have a will and you're in the informal process, that's what your document is going to say. So in this case, because the case I just mentioned, because we have the husband, he has
Mhm.
priority over his children to be appointed. So he, no issues there. Let's say the husband was also gone. Let's say we're dealing with just children, like you were saying, siblings. Um, there is no priority among them. They are all the same. And so that's why if you're trying to do the informal process in that case, and there's two siblings that have equal priority because they're at the same level to serve, if the registrar doesn't know what the other person's position is, they may require that we get a joinder or a renunciation or something from that other person that says, I have the same priority as Stacy. I'm fine with you appointing her. Great. No questions asked. The registrar will let that through. Because I kind of skipped over it, but in the informal proceeding where I was talking about for formal, there's all these notice requirements. For informal, there are no notice requirements, with an exception that I won't go into. When it's somebody who's not related is trying to get appointed, the registrar requires notice ahead of time, but we'll go to still simple situations.
Right.
Siblings, you would just say, if in order for to do it informally, you would want everyone on the same page with who's getting appointed and signing off and showing the registrar through a signed document filed with the court that they're all on board with, Stacy being appointed
Mhm.
versus the other siblings.
Okay. And so it sounds like timeline. There wouldn't be there's no like timeline that you could give for informal or formal because each situation is so different, right? But I
Yeah.
but I guess if we say it's informal, best case scenario, I'm just wondering what's the fastest speed that could, you could go from start to finish.
Yeah. Well, if they fastest speed would be there's one person. So I have a another situation where there's an only child. Um, his mom passed away already, so now his dad has passed away. Mom and dad were entitled to a house here in Kaneohe,
Mhm.
and the son is like, I just need, to get appointed so I can transfer the deed over to myself. No problem. Sign the paperwork. Well, death certificate is the only waiting period. We have a
Mhm.
death certificate for both mom and dad. Once you have that, he's in my office, he's signing the document. I file it that day, especially because it's First Circuit. I submit the paperwork to the court within, like I said, within a week. I mean, it can take longer if they're
Oh.
inundated, but
Mhm.
there was a time where it was the next day it would go. There are
Wow.
sometimes still where it's 2 days later, the registrar will approve it and issue the paperwork you need. He can come back to my office. I can sign the deed, the next day. We
Mhm.
can record it. It's done. You could do it in a week.
Wow.
That is unique, and you wouldn't really go that
Right.
fast for other reasons. But in that situation where there's one kid, one thing,
Mhm.
maybe it's been some time since the parents have passed, so we're not worried about creditors at this point.
Mhm.
Stuff like that, it really can be fast.
Mhm.
But that's a
Yeah.
unique situation.
Right. And I'm sure on the opposite end, there's probably instances when it drags on and on and on.
Yeah, and so I should mention once the court issue, either the court or the registrar, when she gets the document that says Stacy is appointed the personal representative, those are good for 3 years. They're valid for three
Mm.
years from that date. You can ask to have it extended. On the neighbor islands, at least on the Big Island, there's a process where you can ask for that extension informally, again, where you're asking the registrar. First Circuit doesn't have that, and you have to, once you're asking for an an extension, that moves into a judge is getting involved. Doesn't mean there needs to be a hearing. There are ways to do it without having a hearing, but that requires all the interested people to sign off and give their approval for the request.
Okay.
But yeah, there are ones where, and then so let's say the document I'm talking about that you get, it's called letters. You get, and so people, I do also get the question where someone has passed and the kid is dealing with the assets and they say, oh well, the bank is asking me for letters. Is that something that you can just sign and give to me? You know, and I'm like, oh no, that's a probate thing.
Mm.
So letters testamentary is what you get when there's a will. Letters of administration is what you get when there's no will. And it's not like letters like pages of something
Right.
that says dear sir, madam, whatever. It's just that what you call the court document that appoints you, that shows your authority as personal representative.
Mm.
Um, so the letters can be the first time you get it, it's just letters. Once you ask to renew it, you've got first amended letters. Next one, you've got second amended letters. So every time you renew it, you're kind of showing the extension of time. And I can't remember if there was anything. I do remember doing 6 letters once as a clerk. I
Wow.
saw a 6 amended letter. There are probably ones that have gone longer.
Hmm.
But you just have to keep because sometimes in one of my other cases I'm working on, we're waiting on something happening in New York.
Mm.
The person owned part of a parking lot in New York that they're trying to sell, a parking lot. But I
Okay.
imagine in New York, that's
Sure.
probably pretty valuable.
Yeah.
Um, and they couldn't find a buyer, they're working on all of that over there. And once that's sold, there's a portion that's coming to somebody who has passed away in Hawaii. So we're just waiting on New York. And in the meantime, we're just kind of keeping the person here appointed and ready to go for whenever that distribution comes in. So different reasons like that to get the extensions, but
Gotcha. So maybe you can shed some light on the creditors and claims process. So
mhm.
the creditors process, from what I understand, is you kind of put out this notice so that um, any debts or any creditors can kind of stake their claim to assets. I wonder if people need to proactively seek out these creditors, or I think there's a timeline, right? And then it's just, well, you can't go after that. But this is also the time when I guess somebody who might not be part of the will or beneficiary can also come in and stake their claim to, you know, being part of the, receiving some of the estate, right? Is that the same time period?
If someone wants to, if someone wants to get in on a piece of the pie,
Right.
and they're saying it's because they were improperly excluded from a will or
Hmm.
because they're an heir, they have to do that during the
Oh,
court
that's it.
process, the opening of the probate. You have to
Okay. Okay.
establish your status as an heir or a
Oh,
beneficiary at that point.
I
So
see.
you're either going to challenge a will that left you out, or you're going to say, I wasn't identified as an heir in that person's filing, but I am an heir because I'm a child or whatever
Okay.
it is.
So the creditors
Um,
process is just for creditors. It's just for
Creditors,
debts and
yeah,
liabilities. Okay.
yeah. It doesn't mean that those persons, because there are some times where if you were serving as the person's power of attorney or conservator during their period of incapacity and you had made payments on their behalf, or you've got your things you need to be reimbursed for, maybe you are not included in the estate as a beneficiary and you're not asking to get a piece of the pie, but you want to get paid back for something. You're saying there's a debt owed to you
Hmm.
by the deceased person that came into play when that person was still alive, then you become a creditor. But
Mhm.
again, it's not because you're saying you should get a piece of the pie. You're asking about, you have receipts and you want to be
Gotcha.
reimbursed, that sort of thing. But yeah, after a person passes away, Hawaii law provides that for 18 months, creditors can come forward to present claims saying, I'm owed money by the person who passed away. You can shorten that time period to 4 months from the date that the notice goes into the newspaper. So in the formal probate proceeding, you're getting that because you're putting the notice in the newspaper. As long as the notice has the appropriate language, um, notifying creditors that they've got 4 months to come forward and present their claim. Um, if you, once the personal representative is appointed, if they know there are creditors like the care home or
Right.
caregiver, whoever, power of attorney, so, that they know that that person might have receipts, that you can send a notice that says, hey, you have 60 days. I've been appointed. I'm trying to get my arms around everything. You have 60 days to tell me what we owe you, or you're going
Mhm.
to be barred. So that's the big general overview of the creditor's claim.
So, Ken, I'm not advocating for this, and this is kind of not to be conniving, but could somebody say, "Well, I know mom owed this money to this place, but maybe they like we're not going to let them know. We're not going to pursue it, and hopefully it just skates by." Could that be like a thought?
It could be a thought, and then it becomes, why do they, how can, this place, how can they prove that you knew that they owed you
Mm.
money, right? If they can prove you knew, you can't feign ignorance, But
Gotcha.
yes, as an attorney, I get questions like that all the time where I'm
Right,
like,
right.
I give my sort of practical answer, and then I'm like, but as an attorney, do not lie, cheat, and steal.
Sure, right, right. Okay, and so there's this whole like a priority of debts that get paid, right? Because I'm
Hmm.
sure if
Yes.
depending on who's coming forward with what debts, there's priorities. And the same is true for, like bonds and investments, right? Certain people are entitled to get paid out first if a company goes bankrupt and
Hmm.
all that kind of
Hmm.
stuff. Um, so what's interesting is the debts could almost take away some of the assets that were thought to be inherited. And if they were, what is it called when it's like specifically claimed? Like you can say, I want to give this amount of dollars, $20,000 to this person.
Hmm.
Um, but if, or let's say it was a larger number, let's say it was 1 million, but then creditors came and now there's only 800,000. So the creditors can eat away at the remaining assets. And then I'm sure there's a whole process for how do you divide up amongst the beneficiaries assets that are less than what was kind of specified, right?
Yes. So moving different parts to your question, and yes, you're right. So there are different kinds of expenses of an estate administration, and it takes priority. If there's not enough to cover all of it, there's priority for who gets paid first.
Hmm.
And then let's say we've paid off the debts or expenses of the administration, and like you said, there's not enough left to cover we call those specific gifts or
Hmm.
specific distributions. When you say, I want X amount of dollars to go to this charity, to this friend, to this whatever,
Hmm.
and everything else will get split between my kids. So if there's not enough to cover those specific distributions and the residuary, whatever, the specific gifts go first. So that's also an
Hmm.
important caveat to tell people during the planning, because that's probably exactly the opposite of what the parent was trying to accomplish. They were
Hmm.
like, well, I want this to go. So you can avoid that by putting certain language in, or, again, there's things you can do in documents to prevent that, or to be clear that you only want to give those gifts if your kids are getting a certain amount, or that
Hmm.
you have to be very specific about that. Um, I also did want to mention, as we were talking, the thought popped up. The personal representative or the heirs or the beneficiaries do not have to cover the deceased person's debts personally.
Hmm.
Like a personal representative coming into an estate that maybe has $50,000, the deceased person had $50,000, and then the personal representative is getting all these claims from creditors, and it turns out there were $80,000 of debt. There's only $50,000 of assets. The personal representative themselves does not have to dip into their own pocket to cover the 30,000, like by any means. Or if it turns out there are no assets because all that was left was real estate and it was encumbered by a reverse mortgage or something that now has exceeded the value of the home, and there's all these other creditors, so there really is no estate asset at the end of the day, but we didn't know that when we started. Again, the personal representative doesn't then have to start personally paying for any of these things. But the idea is if there are legitimate creditors,
Mhm.
they get paid before beneficiaries receive anything.
Gotcha.
Did that
Okay.
answer the question
Yeah,
about the
yeah. No, no,
specific? Okay,
yeah,
yeah.
definitely. And then the cost around probate, uh, I guess it varies a lot, but you got to think there's court filing fees, there's attorney
hmm
fees, there's
hmm
the personal representative if they you got their fees. There's probably appraisal costs. I don't know if
hmm
for certain assets you might need to get it appraised so we can decide the amount that gets divided up. And then you have accounting if you got to work with a CPA to kind of go through all that. So I guess what I'm getting at is that the cost can vary. It can be expensive depending on what you have going on, but it also probably can be relatively affordable if it's pretty straightforward, right?
Yeah, so in the example of the family where, the husband's being appointed, there's a house, it's the mom had a 1/4 interest, we're past the creditor claim period, like they just have to pay the my attorney's fees and the as part of what I charge, and I think most of the attorneys that do practice in probate, we pass on the filing fee to the client.
Hmm.
The to open a probate is $215. That's the filing fee. Um, and you don't have to pay that every single time. That's just to get, the case number. There are certain things that might add on later, but essentially it's $215 to open a probate from the court side. The attorney's fees are always going to be different. I charge a flat fee. I think most do these
Hmm.
days. There are some, though, that may just charge hourly based on that attorney's hourly rate. Of course, if they're charging hourly and they have to go to court and they have to deal with multiple beneficiaries calling them, that's where the costs go up. But for the simple ones, if it's for, this client I have, it's a flat fee plus the filing fee, they know what they're dealing with. And once it's done, it's done.
Hmm.
Once the property is transferred over, that was their experience in probate. It was quick and it was, I don't want to say inexpensive, but they knew what the cost would be and it was a sort of one and done payment because they're not going to get it appraised, I don't think.
Hmm.
Because they're not, well, that's another issue. They should.
Right,
There's date of death appraisals are important for real estate for capital gains tax
right,
purposes.
right, right.
We won't talk about that, but yes,
Sure.
an appraisal, I think those run like 500
Hmm.
to $1,000 depending on the property and location and size and all of that.
Right,
Um, but yeah, let's say you're also going to pay an account to do like a final tax
hmm,
return or something, those are, 1,000, 1,500, something
right,
like
right.
that on the expensive end. If you've had someone who's filed your taxes your whole life and then they're going to do your final one, I mean, you can kind of anticipate what the cost of that is going to be. But that's part of what I tell folks who are maybe questioning, like, do I need to do an estate plan? Like, will probate be so bad? I like to think of it as control. You know today in 2026 what your estate plan will cost.
Hmm.
You know today what the laws are about who would get things if you passed away without a plan. Those laws can change,
Hmm.
Attorney's fees costs are going to change. My attorney's fees today, 13 years into practice, are very different from what they were two
Sure.
years into practice. So you pay now, you know what the cost is, you got it set up, or your beneficiaries pay later from your estate. We don't know what that amount will be. It goes up if anybody's fighting you. You lose control to a certain extent of, I always say closed universe. You don't have that closed universe that you're dealing with. You're in oh, we're opening a door and we don't
Right.
really know what could be on the other side.
Sure. And then the retitling of assets. So things can just get distributed to the heirs, right? Let's say there was money in a bank account and it gets cut a check or whatever it is. Like I'm very familiar with how IRAs get retitled and all that, but that's passing through the beneficiaries.
hmm
Um, whereas like let's say I had a classic car and I have my house. And so we've gone through this process here and so then the retitling is really on it's not on the personal representative. I kind of like this classic car example. Let's stick with that. So you have a few kids, right? And the eldest son gets this classic car, and they go through process, and okay, it says so the retitling doesn't happen by the courts, doesn't happen by the personal representative. It's just they're given a document that they can then take, and then they need to go through and do the retitling of that asset, whatever it might be.
It is on the personal representative to do that, though.
Okay.
Like the son who's entitled to the car, like I said, when the banks or the DMV, the receivers of the court documents, they're looking for those letters. They just
Mm-mm-mm.
want to know because the letters will say the estate of Stacy
Okay.
Takekawa, and John Smith has been appointed as the personal representative of the estate of Stacy Takekawa. So the classic car that Stacy Takekawa owned, the DMV knows Stacy Takekawa and they know they need to deal with John Smith.
Mm.
If I left the car to Keone,
Hmm.
Keone cannot go to the DMV and say, there was a probate. I'm supposed to get the car. Here's the
Mm.
will, give me
Right,
the
right,
car,
right, right.
So it is on the
I
personal
see.
representative to retitle the assets.
I see. And then
Yeah.
the real estate retitling, that's frequently often done by, like, I'm sure, do you estate planning attorneys have
Yes.
their hand in working with the getting that all squared away for them?
Yeah, usually for real estate, going out of an estate or out of a trust of a person who's passed away, the attorney handling the administration or the probate usually does it. If
Mm.
not, it's not a difficult, you don't have to go to like a real estate attorney or something, the estate planning attorneys can even do that usually.
Okay. So let's see here. We covered a lot. This is a good conversation. I'm learning a lot. Hopefully the listeners are.
One of the
Uh,
things I wanted to go back to on the costs, and it's on the outline, the thing that I do think people are is a misconception about costs of probate is that it matters how much money there was in the estate. Like, and I think going into other states, there in other states, the attorneys who handle probate are entitled to fees based on the value of the estate. That is true
mm,
in other states. That is not true in Hawaii.
hmm,
It's not like because the laws in those other states say if there's $1 million estate, the attorney's fees for doing the probate is $3,000. If there's they have a schedule. Hawaii doesn't have anything like that. It could be we're dealing with empty land on the Big Island that might be worth 8,000, 10,000, or we're dealing with the residents plus three homes and we're $4 million territory or something like
mm,
that. The my attorney's fees do not differentiate in that
mm,
situation.
mm, mm, mm,
But probate costs the same no matter what assets we're dealing with.
mm.
Another misconception is that the state, the government is taking a piece if you're in
Right,
probate,
right.
and that is not true, other than the filing fee, I guess.
Yeah,
There's no, because you're in probate, the state gets 10% or it's taxed differently somehow or
right,
anything like that. It doesn't, there is none of that. So
right.
that's not true.
That's that's a good one, and that's something I've heard. I don't know if other people have too, but you hear like oh, you got to do this because otherwise the state is going to get your assets. The state very rarely probably
Yeah,
takes your assets, right?
I
Like,
think with that, I think what people maybe, and again, with with most things I hear from clients in Hawaii, it's I heard this, my cousin had
right,
this,
right.
my neighbor's friend had that, So let's say there's a bank account and it n- the person who owned it passes away. This Stacy Takekawa had a bank account, and then Stacy passes away, and nobody came forward as personal representative, as
Mhm.
payable on death beneficiary. Maybe there was no beneficiary. There's just an account sitting there, and nobody's dealing with it. The banks, at a certain point, and I don't know if it's an internal policy or how they're regulated, but after a certain number of years, I believe, they turn that over to the state, and that's what that unclaimed
Ah, yeah.
property is. So I don't know if everyone's aware of like the State Department of Budget and Finance has this unclaimed property division. You can go online, you can search for names. I kind of do it all the time for my relatives,
Right.
myself and my relatives, and sometimes it's like a refund of a something there's utilities are on there for some reason, or
Right.
there's payouts from these bank account. There's a $10,000 bank account. It will show up there and it stays at the state budget office or the Department of Budget and Finance in that unclaimed property for again a number of years. I don't know off the top of my head what it is, but there is a statute for how long it stays there. Once it stays there long enough, yes, it escheats to the state, that ESCHEAT word that people will see. So the
Gotcha.
state does get your assets at some
Mm,
point, but it's a long time
right, right.
where there are multiple ways for people who might be entitled to those funds to go after and collect those funds. But yes, in a sense, that's the only time that the
Gotcha.
state would take your assets. And I wouldn't necessarily call that taking your assets at that point.
Right. Yeah, it's funny how these things come to be, these thoughts. I hear
Hmm.
a
Hmm.
ton of it with finance and investments. There's all kinds of opinions and stories, and
Yeah.
I come across and I say, I don't know where that came from, but that's just not
Yeah.
right.
Yeah. The other myth, I mentioned this last time, but the thing about reading of the wills, people will call my office and, my dad passed away and my sister's not telling me any information, but can you just tell me what day the appointment is for us all to come to your office for you to read the will? Like,
Right,
that's
right,
happened
right,
a
right.
handful of times where I'm like, oh, I know where you're getting that
Yeah,
from. You're getting that from the movies or from
sure,
TV shows, and
sure.
that does not happen in Hawaii. So,
Right.
or maybe it does. Maybe some attorneys do that. I don't know of any. I've never heard anybody who says they do that because that's just not how it works.
Right, right, right.
That's
Yeah,
not required.
we always see, a large group of heirs sit around a giant nice
Yeah.
table, and
Yeah.
we're gonna go line item by line item, and
Yeah.
I'm
Or
sure
like
that's
Knives Out is my favorite
right.
sort of more recent, film
Yeah,
depiction of that, where the whole family is there, right? And he
right.
left it all to his caregiver nurse at the end, and it's the
Yeah.
whole, everything goes up from there. Yeah.
But
That doesn't happen here.
I think that points to, and I want to do a shameless plug here for financial advising and working with your advisor or your CPA, and how the estate planning stuff doesn't happen in a vacuum, right? I
Hmm.
mean, and you want to communicate, you should be communicating this stuff to your heirs, and you should be planning, with how you position your assets. What are the tax strategies and the tax consequences of certain, the way certain assets are going to pass on. Um, but I think that whole idea, like, it made me think about with like you're sitting around a table and you're reading everything out. I think it's good to be open with your children or your family or whoever, and kind of lay it out there at some point so everybody kind of knows what's happening beforehand, and hopefully there's that minimizes surprises. But I guess also there might be cases where that might cause more issues. So
Yeah, but I'm with you. I mean, I do have clients who sometimes it's hard to even get them in there to talk
mm,
about their own. Some of it's cultural, there's a
mm,
there's a certain aversion to talking about death.
sure.
Um, so then there's an aversion to even planning for it. But I can see where some people are a little more traditional or old school, or it's none of their business.
Right,
It's
right.
my money, it's my stuff. They'll be lucky if they get anything. That's
Hmm.
fine and that's true. If the goal for most people, it seems to be the goal is peace and
Right.
ease and, like you said, simplicity. Even if there's a higher net worth, we're just trying to make sure we don't want the family to fall apart over this.
Mhm.
In that case, when people are doing that, even when it's an equal split, and they're saying, well, it's an equal split, so that you should be fine. That sometimes isn't what the kids think should happen. Again, primarily when there's a child who's providing care to the parent, or who has taken the parent in to live with them, for
Mhm.
the end of life. There's sort of a, well, why am I getting the same as my brother who didn't show up once?
Mhm.
So the more you talk about it, the better it will be for the ease and simplicity and, cohesion. If it brings up a fight before you pass away, if you're sitting at the table and you're saying, here's the plan, guys, and anybody storms out or gets upset about it, well, that's information you have about how you're structuring
Sure. Right, right.
things. So I think it's beneficial, because if it were me, and that's happening, well, that person's either getting way less or maybe
Mhm.
nothing, because how dare you? But that's,
Right, right.
that's to each his own. But I think if the goal is simplicity, cohesion, all of that, the more people know, the better. And the caveat to that is, if you're going to be doing that, have it where we're all at the same table at the
Mm.
same time,
Right, right.
because Parents will do it, especially for different reasons at end of life care, you know, telling child A what child A wants to hear, telling child B what child B wants to hear, telling
Right.
child C what child C wants to hear. Meanwhile, the plan is none of those things, or a blend of those things, or only
Right.
one of those things. Then you're going to create more friction. You think it might make your life easier to just deal with your kids that way, but it's not going to help them deal with each other. So that's why
Right.
it's better to have that all out in the open, I think, depending on
Yeah.
what the goal is.
No, absolutely. I agree. And I think I want to make one other point about, it's this conversation is a good kind of a good kind makes a good case for consolidating your assets. And what I mean by that is oftentimes what I find is you have when you have a couple, one spouse is usually is way
Yeah.
more in tune to what they have, what's going on, and the other one is kind of left in the dark. But the same is true if you're maybe your other spouse passed away, or you've just been single and you know where everything is, but everything's going to pass on through a will, and maybe it's a good case for consolidating. You don't need to have three different 401ks, maybe unless you have a good reason, right?
Yeah.
From old employers, like consolidate these things and sort of let whether it's your spouse or your children know, even if you don't need to tell them what the assets are and what they are, just say there's this document that has everything you'll need to know for where it is, because that can create, I'm sure the inventorying of things can sometimes be chaotic.
It almost always is when you've got people who haven't been vocal with, and it does happen to spouses, and it's, you know, so my husband passed, my wife passed, she handled everything, he
Hmm.
handled everything. I don't even know. I know our primary bank account because I have the checks or the debit
Hmm.
card, whatever. I don't know where my retirement is. I don't know what investments we have. I never filed our taxes. I signed the return,
Hmm.
it it and back to the probate where you have the letters, you do the administration, you close everything down, and then come to find out there's this other account or thing left over. And if it's the
Hmm.
third 401k that
Right,
it's
right.
like, oh,
Yeah.
well, I didn't know there'd be three.
Yeah.
So absolutely. And the I have a little bit of a weight lifted when I'm meeting with clients and they have a financial planner and they're
Hmm.
like, they have all of my accounts
Hmm.
except my, employee, my pension or what, the one thing I have with my employer on this side. But they've consolidated everything. I've put all my stuff with them. Great, because then it is okay, great. When the time comes, we're only going to have to make a couple of stops here. Or even more important, the financial planners can really help because financial planners have the discussion with the clients about goals and risks and what's the money for. And they've been
Hmm.
on this journey with this person, you know, and they've probably met the kids too. And usually I have, financial planners, and it's like you dealt with my parents. So then
Hmm.
my parents trusted you. I trust you. We kind of all go together. As an estate planner, I'm not talking to my clients about like, what is your asset strategy here?
Right,
I just
right,
say,
right,
what do you have? Because we
right.
want to make sure it's included, with the trust or not, how it make sure things are titled correctly. When there's a financial planner that I can just double check with them and say,
Hmm.
hey, I'm working with these clients, we just set up the trust. Here's the certificate of trust. Can you make sure all the beneficiary designations are what they should be?
Hmm.
Or if the client says, yeah, I want to make sure my kids are already getting the retirement account, so let's have the house stay in a trust for the grandkids or something like that.
Hmm.
Well, maybe they named the grandkids as the beneficiaries of the retirement
Right,
accounts
right.
because there was a miscommunication with me or with the advisor. So it's like when we're all, like you said, not in a vacuum, when it's all like a team approach to planning, better results 100% of the time.
Yeah. Well, Stacy, I really appreciate you taking the time here. Hopefully, the listeners learned something. I learned a lot here. It's a great conversation around probate. Anything we missed, you think? I think that was
I'm
pretty.
sure there is.
Yeah, yeah, yeah. No, yeah, there's all these nuances, but or
Right.
I should have said anything you care to add.
Nothing I care to add other than I always forget to do it at the top, but none of this is legal advice.
Yes.
All of this is for educational purposes only. If you have any questions about anything, talk to an attorney. go to more of these presentations, seek out the information. Do not rely on Google or AI searches because every state is different. And even within families and situations, every situation is going to be different. And so I just think speaking with trusted advisors, financial planners, attorneys, that gets you the information you need to make informed decisions and, make sure you're getting the right answers.
Great. Our guest today is Stacy Takekawa. Stacy, thanks so much for joining us.
Thank you, Jason.
The opinions and statements presented on this show are for general information only and are not intended to provide specific advice or recommendations. Never make any investment or financial decisions based on information offered on this show without first consulting your financial, legal, or tax advisor. All economic and performance information mentioned on the show is historical in nature and is not indicative of any future results. All indices mentioned on this show are unmanaged and cannot be invested in directly. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. Lastly, all opinions expressed by Jason Cutitta and any guests on the show are solely their own opinions and do not reflect the opinions of or are endorsed by Toba Financial. For Jason Cutitta, investment advisory services are offered through Toba Financial LLC, a registered investment advisor offering advisory services in the state of Hawaii and in other jurisdictions where exempt from registration.